You're listening to Civic Media. You can tune into any of our live shows on any radio station across the state with the Civic Media app. Find us in your phone's app store and listen anytime, anywhere.
Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
This is Amicus, a law review, and my name is Jim Santelle. I'm your host for this broadcast on the broadcast stations of Civic Media throughout the state of Wisconsin and beyond. I am joined in the Civic Media studio this weekend by my excellent producer, Max. And together, as always, we are encouraging your questions, your inquiries, your comments, your perspectives about things on our ambitious, but as always, achievable agenda, our syllabus this weekend. Thank you. Thank you so much for joining Max and me once again for our discussion of all things rule of law related, justice related, government related, and we've got a lot of it this weekend to talk about. It once again has been a busy week in the area of rule of law issues. And we're going to use this opportunity, as promised in our previous broadcast, also to initiate at least one, maybe even two new segments. The one that we're certainly going to initiate this weekend is called Injunction Function. And yes, it's perhaps a throwback to things you may recall from your youth having to do with language on the television. This is going to be all about highlighting, as we promised in our previous broadcast, and going in depth on some of the most significant cases pending right now in the federal district courts, in some cases appeals courts, having to do with challenges against these many executive orders in all sorts of areas issued by the President of the United States of America, his name, Donald Trump. We're going to spend some time talking about the function of the federal courts, receiving and resolving challenges to many, if not all, of these executive orders. We're going to spend some time doing a little law school this weekend, talking about what an injunction is. We're going to talk about what a TRO is, a temporary restraining order, how that works, what a preliminary injunction is, what a permanent injunction is, just because it's important to understand the process, the procedure of what's going on in these many cases. And yes, indeed, as we have commented in the past, and as everyone, regardless of what side of the political aisle you are on these days, everyone commenting that it is a lot. There is a lot going on, a lot to understand in trying to make sense of what is going on in our federal courts, frankly, our other courts around the nation, and what's going on in government. How is government responding? And as we have talked again on this broadcast in the past, rule of law issues about compliance, whether or not the words, the commission, the directive, the orders of federal judges are obeyed, are followed, are pursued by the other branches of government. What in fact happens if indeed a president says, no, I'm not going to do what a federal court judge has commanded, ordered me to do? We'll talk not only about that horrific implication, and yes, indeed, that is getting right up to, if not crossing into, the area of, yes, indeed, a constitutional crisis, a word that perhaps phrase bandied about much too much these days, but now coming upon it. Because what does it mean? It means we've come to the end of the constitutional process. There's no more check and no more balance. The entire system, our entire system, including federal judges, issuing injunctions, issuing TROs, is premised upon the fundamental notion. This is Madisonian democracy. This is what a republic is premised upon. All of this depended upon other branches of government abiding by, and yes, sometimes challenging, the orders, the directives, the legislation of another branch, but always following in such a way that there is another remedy, there's another avenue to pursue. If, in fact, any of those branches, we know there are three of them, there's a judicial branch, sometimes referred to as the weakest branch of government. We'll think more about that. There is the executive branch, obviously intended by James Madison and others to execute on the laws issued proposed and put into law by the first branch of government, which is the legislature, obviously with the signature of the president as all. Those are the three branches of government, and checks and balances between those three branches are what keep us from anarchy. What happens if one of those branches says we're not participating anymore? We're not going to abide by the directions of a fellow branch of government. That is indeed when the constitutional process, our Constitution contemplates the making of laws plainly, as do our founding documents. When in fact you come to the end of that, that is when the crisis is afoot. And that is when a republic, as Sonia Sotomayor and others have commented just about 8 months or so ago, that's when our republic is in danger. That's when she and others have fear for the future of our nation. We're going to talk about all of that in the context of what judges do when it comes to injunctive relief. We're calling this, once again, Injunction Function, because we're talking about the function of the federal courts. What do they do? How do they do this? And how do we make sense of these many cases that are right now pending in federal courts around the country? We're going to focus necessarily, again, as promised in the past, on count them, five cases, all of which, every single one of these in the courts just in this past week. What are those cases? We're going to spend some time necessarily talking about cases involving everything from an attempt by the EPA to recoup huge amounts of money given out under the previous administration to address climate issues. We're going to talk about the Transgender Troop Ban imposed by the president just a day or so into his presidency. We're going to talk about the Social Security Administration and this attempt by the Musk team. Notice I'm not calling it Doge, and I will not call it Doge because the D of Doge is a department, and it is not a department. It is not. We're going to call it the Trump team, the Musk team, probably the Trump team as well. The Trump team, the Musk team, attempting to gain access to Social Security information. We'll talk about what a federal district court judge did in that case. We'll talk about USAID funding and the shuttering of that agency and what another federal district court judge did just this past week. And first and foremost, we're going to talk about the case that's on the mind and, yes, the hearts of everybody right now. That is the case involving those Venezuelan immigrants who are now in a high-security prison in El Salvador. We'll talk about what a judge in the District of Columbia has done just in hours ago, just in his processing, his administration of that case. Those five of them, deep dives in what's going on, not only to understand them, but also to underscore the role that judges play, the functional role that they play in imposing initially these TROs, these temporary restraining orders, then moving on to preliminary injunctions, and perhaps one day moving on to permanent injunctions. And we'll talk about all of that and what the word injunction means, actually. That is the first and principal part of our syllabus, our agenda for Amicus, a law review in this, principally the first, but probably also a portion of our second hour on this weekend. Necessarily coming off of my comments about the interrelationship between the branches of government, we need to talk about something else that happened this week, and that is this low-level sparring. Very low level, not especially aggressive on either side, but John Roberts especially being very tepid when it comes to pushing back on the President of the United States, who suggested that some of these judges, at least one of them named James Boasberg, he's the D.C. judge in the case involving the Venezuelan immigrants, should be impeached. We'll hear what John Roberts said in a very tepid response. We'll hear what Donald Trump is saying also in response to that, suggesting along the way that time is of the essence, talking about what may happen if indeed something happens before it's too late. Those were his comments just this past week. We'll talk about that spat between branches of government and what more should actually be going on, what more the American public should be hearing properly if we had a fully robust judicial branch here, at least with respect to the Supreme Court, that would say that no, indeed, there's more than just impeachment threats going on here from the president, but also push back on this president and his comments about the judiciary that undermine the very understandings about what judges do in America. We're necessarily also going to talk about what our Attorney General, the chief federal law enforcement officer in our nation, appointed by the president with the advice and consent of the United States Senate. You know her name is Pamela Bondi. She used to be the Attorney General of Florida. She has been our Attorney General since the first weeks of this administration. We will talk about the stunning things that she has said. Yes, also in this political arena. We will forgive. We will forgive a lot of things that are said by members of Congress, by the president, by other members of the executive branch, falling in the category of partisan and political statements. Not from our Attorney General, not from Pam Bondi, and yet she did it. She has talked about the obligation, the requirement that the executive branch do what it wants to do absent any judicial oversight, and speaking specifically about the Boasberg decisions, that Venezuelan immigration case. Stunning things to say, stunning rejections of the very notions upon which our government has been built, our republic has been premised. Our Attorney General, the chief federal law enforcement officer in our nation, giving us a lesson in civics that is unknown in 250 years, and contrary, I would offer, to everything that she has been taught at the Stetson Law School, which is the law school from which she graduated in Florida. Interesting to go back to that law school and ask if the dean, if the provost of that school would embrace the things that she said about the capacity of one branch to say no to another. To say, no, indeed, we don't have to follow what a judge, as she said, an unelected, singular federal judge telling us what to do. Our Attorney General saying she doesn't have to follow that. The president doesn't have to follow that. Undermining, turning on its head, again, well over 2 centuries of understandings about our system of justice and the rules by which we operate in this nation. All of that coming up. And finally, time permitting, we're also going to talk about some studies in capitulation, which have also been animating our news this past week. Capitulation by, yes, very recently, Columbia University, and yes, indeed, a law firm, a big law firm called Paul Weiss. Both of those entities, under different circumstances, capitulating to the executive branch, capitulating to the president when it comes to his wanting to stop their activities, wanting them to engage in behavior, and doing it principally by virtue of executive threats to shut down a major portion of Columbia University, $400 million in funding, and to shut down Paul Weiss by virtue of telling them they can't get access to federal courts and federal buildings, other mechanisms attempting to push back on our academic institutions and our law firms and lawyers, as we've talked about before. All of that and more. It's a lot coming up on this edition of Amicus, a Law Review. Stay with us for all of that important discussion here on the broadcast stations of Civic Media.
You're listening to Civic Media. Stay up to date on the latest news and information for your local community and Wisconsin by signing up for our free email newsletter. Visit civicmedia.us/email to get started.
This is Amicus, a Law Review on the broadcast stations of Civic Media. My name is James Santelle. I am your host this hour as well as next hour. As always, amicus meaning friend. Amicus curiae, friend of the court. The concept, the idea, we take our name from the Latin, from the legal term as well, being a friend to the community, providing information, insight, perspective that is balanced and reasonable. You can disagree with policies. You can disagree with what judges do, what our legislature does, what our president does, but we need to have a fundamental understanding of how this works, the basic terms and conditions, the processes, the policies by which all of these institutions of government work. And to that end, in this first portion of our broadcast this week, and we're going to spend some time doing a little bit of law school as we sometimes do, talking about injunctive relief. What does that mean? What does a judge do when he or she imposes an injunction? We'll do some of that as we begin our examination of 5 different cases in which judges have enjoined the executive branch from doing what it wants to do under these executive orders. All of that, inviting your conversation, your comments. As always, the phone number here at Civic Media is 855-752-4842, 855-752-4842. You can call in. Max and I will take your call. You can also drop a comment, a question to the studio chat, and we'll acknowledge and respond to that as well. Be a part of our discussion, which again begins now with a bit of law school here on the weekend, necessary to understanding what 5 different judges, all of them federal district court judges, have done just in the past week, issuing injunctions of various natures with respect to what Donald Trump and the administration is attempting to do in 5 very different areas of our lives and our livelihoods. Let's talk about what all this means. What is an injunction? What does that mean to enjoin something? Well, the simple way of thinking about it is it's to stop something. An injunction in many situations is a circumstance where someone runs into court and says something very bad is about to happen. Most often when I was in law school, the easy way to understand this from my professors had to get through my brain would explain, what if there's a fire going on? What if there's a flood that's imminent? What if a dam is about to break? What if something else is about to happen? And you can't wait. You can't wait for that thing to happen before you get a trial on the merits, which could take days, weeks, sometimes even years. What do you need to do to stop the bad thing from happening? In many cases, injunctions can also be affirmative in nature. It's not just stopping something. Maybe it could also be, and here's the double negative, could also be stopping someone or an entity from not doing something. You add those 2 knots together, it requires the government in some way, a particular private party, to act affirmatively in some way. It is a directive from the court faced with a circumstance that needs some immediate attention. Something bad is going to happen. That at least would be the petition of the challengers saying, Judge, help us out, make certain that this bad thing does not happen, and keep it in place. We often talk about the status quo, right? Keep these things in place so that we can come in and argue with you and argue to you and argue against the other side about the merits of our claim that we need to stop this permanently. But right now, stop this thing from happening, whatever that may be. In the particular cases that we're going to spend some time talking about, it has to do with orders of the executive branch that are indeed affecting people's livelihood when it comes to employment, affecting the engagement of our nation overseas entities, affecting access to Social Security information, the capacity of transgender troops to serve our nation, the capacity of people to get monies which they were given to ensure the safety and security of our environment going forward, the safety and security of our people when it comes to actions undertaken by the president under a centuries-old statute. All of that in the category of requests for injunctive relief. And again, as you will see, as we talk about these cases, in each one of them, you have got private parties, sometimes former government officials, coming into court and saying something bad has happened. Judge, put in place an injunctive order, preliminary in nature, temporary in nature, to stop this from happening, stop the bleeding, stop the damage from happening, and then we'll come back and when we've got a bit more time and explain to you why that preliminary injunction, that temporary restraining order should be expanded into a larger scope. And that's where we begin once again. What is happening in virtually all of these cases is when these judges are confronted, sometimes, as we know just in the most significant, most timely of these cases, quite literally a week ago when we were on the air last weekend, this was breaking, coming into Judge James Boasberg's court. A request from private parties, private individuals to stop the government, our government, the United States government, from sending overseas to El Salvador hundreds of Venezuelan immigrants coming into Judge Boasberg's court, yes, indeed, on a Saturday. As a footnote, our Attorney General has bemoaned the fact, believe it or not,
that the courts are somehow open on the weekends and that her attorneys are required to go in and defend against these things on a weekend. Well, Madam Attorney General, once again, whether a U.S. attorney, Attorney General, you are in those positions 24 hours a day. It's outrageous that you would suggest that somehow justice is suspended during a weekend and that the very petition running into Judge Boasberg's court was untimely somehow because it happened on a Saturday. Putting that silliness to one side, the request in the concept, the notion of a temporary restraining order, Judge, you don't have the time. We don't have the time. The parties don't have the time right now to stop this bad thing from happening. So enter a temporary, heavy emphasis on that, typically maybe 5 days, maybe days, could be even hours if you need to make it that limited, a temporary restraining order. The restraining part of it, the R of TRO, tell that party, in this case the government, to stop doing something. Tell them to keep their actions at bay. Tell them that the decision about the permanent injunction has not yet been entered. But while we can preserve the status quo so that there is not irreparable harm, we'll get back to that in just a moment or so. That's what these judges are doing because of the need for immediate action. The plane is taking off. USAID funds are no longer going overseas to help people who are starving. There is access to Social Security data that's going to compromise the safety and security of our nation's Social Security residents and citizens. There are people in our United States Army who are being prohibited from serving immediately. There are entities that have gotten huge numbers of monies to keep our climate safe, and all of that is in jeopardy right now. Enter a TRO, a temporary restraining order, Judge, and tell the government at least to stop doing what it's doing to enforce those executive orders so that we can come back in once again and ensure that you, Judge, and all the parties and the public, federal courts are public entities, that the judge can have a full and complete understanding of the merits on both sides. And oh, by the way, to the extent that a TRO, sometimes it's yes, indeed, sometimes it's ex parte, which means that the judge is hearing this because it's in such an emergency basis without the other side there. And that may strike many people as without due process. It is necessary from time to time. We'll talk more about how a TRO gets entered and what happens after a temporary restraining order is entered by a judge to stop the thing from happening immediately, and what happens after that, and what are these judges doing right now in our federal courts in the United States of America. Stay with us here on Amicus, a Law Review.
This is Amicus, a Law Review. My name's Jim Santelle. I'm your host this hour and next hour as well, along with Max, my producer, taking your phone calls, taking your comments at 855-752-4842 as we do a little law school this weekend, talking about injunctive relief, INJUCTIVE, an injunction. Technically meaning to stop something from happening, but could also mean compelling a party to do something, telling them to stop not doing something, the double negative there. And that's what's going on right now as all of these private parties, sometimes could be other parties coming into court, asking judges generally. It happens all the time in state and federal courts, coming into those courts and asking a judge to stop something from happening, stop something that is bad. That presumably would be the position of the challenger. Obviously, the other side would say, no, nothing bad happening here at all. You don't need to enter any injunction at all. And that's where we get the contest. In at least these 5 cases, many other circumstances out there in which this issue of injunctions, injunctive relief, and yes, indeed, TROs is at play today. So how does this work? You file your civil complaint. You go into the clerk's office, file that complaint. You set forth the basis for your allegation. And no, it is not the case that a judge will automatically just get out her or his stamp and say the TRO is granted. I'm stopping the party on the receiving end of this civil litigation from doing what it has been doing. judges do have an absolute obligation to do a first level and sometimes even in-depth review, even at the TRO level, before they issue a temporary restraining order. It is an order of the court. Yes, indeed, it's important to understand, contrary to what our government has been saying recently, contrary to what the Department of Justice has been saying recently, that if a judge says something from the bench, what she or he says is the law. It is the order. Yes, it's often codified after that in a piece of paper, a written document in which the words are set forth in clear language. But the order comes out and it is effective at the time of the judge articulating that order. That's very important when it comes to this Venezuelan immigrant case and Judge Boasberg in particular. That's happened. That happens then that when the judge scheduled this on for a temporary restraining order hearing, if it is so urgent in time, can happen ex parte. That means without the other party present. Judges typically don't like to do that because they like to hear from everybody, at least at the start of the process, sometimes not necessary, if indeed the building is on fire, the dam is about to break, something else is about to happen that cannot be prevented. You cannot call. Don't have quite literally hours to take care of ensuring that there is a full exposition. That's the reason why it's temporary. The judge will say, you know what? It appears to me that there may be a basis for doing this. And yes, indeed, there are times when TROs are not granted because a judge can see facially there's no claim to relief here. We'll get back to the standards about this in just a moment or so. But if a TRO is entered, if the judge says, yes, I'm temporarily restraining this party from doing something, he or she will almost always say, and we're going to have a next hearing. Because of the temporary part of this, we get you all into court. We're going to make certain the other side knows all about this. We're going to get you back into court, typically within sometimes hours, most often days, sometimes weeks, so that's spreading a little bit thin. And at that time, we're going to have a fuller hearing, a more robust hearing on the merits of your claim, challengers. And yes, I'm also going to entertain the position of the opposing parties on why that opposing party thinks that the challenging party is wrong. I'm going to listen to all of that. I may take some testimony. I may hear about the law under which the particular temporary restraining order, under which the preliminary injunction is sought. We're going to argue about that. We're going to get testimony, evidence. I'm going to do a hearing in the nature of a trial, the kinds of things that you would otherwise see on television. Not exactly like that, of course, but that kind of proceeding where indeed you get into the weeds of a particular challenge. That's what happens at a preliminary injunction hearing. Those are the kinds of things that the judges are ordering right now. After the TRO is in place, it does compel the TRO, the party that's opposing the challengers, not to continue what it's doing until the time of the preliminary injunction. And at that time, the judges then have a question to ask and to be answered by the parties and ultimately by them. And that is, what are the standards? What should we do here? What are the standards under which we should turn this temporary restraining order into a preliminary injunction, maybe ultimately a permanent injunction? Maybe that would be a trial down the road, maybe weeks, maybe months down the road. What are the standards that are applied in federal court and also in state courts when those injunctive orders, those injunctive requests are reviewed? Here they are. Is there some risk of irreparable harm absent intervention? Again, it's injunction. It's preliminary. It's temporary. What happens if indeed the courts do not intervene to stop something from happening? Is there and can there be identified a clear risk of what's called irreparable harm? Money generally is not that. Just because you're going to lose money typically, can sometimes, but typically does not support a finding of irreparable harm. But the notion, once again, is if indeed monies are not given to an overseas group that is going to be otherwise not providing those monies for a group of a population somewhere that's starving, if indeed the information provided in the public domain, or at least given to the Musk team, compromises safety and security of that information, once that's done,
Once that is done, you can't bring the cows and the horses back into the barn, right? There is irreparable harm, and so the risk of the irreparable harm has to be identified. If you don't do this right now, there will be damages, and you can't recover that down the road simply by paying someone money. The harm is much beyond money. That's the risk of irreparable harm, absence of intervention. And then there's another aspect of this, which I also mentioned just in passing, and that is this. There's got to be some proof of a likelihood of success on the merits. The challenging party, the petitioner, the plaintiff, has got to come in and say, you know what? Not only is there irreparable harm, but probably when we get to that final trial, that final request for a permanent injunction down the road, there is a good indication, a pretty solid indication right now that I, the party seeking this injunctive relief, have a likelihood of being successful on the underlying merits. When we go to trial, I'll be able to prove to a judge, to a jury, that indeed there has been harm here, that something needs to be stopped permanently, and that the merits of what I'm saying are supported by the Constitution, by a piece of legislation, by a statute, by a regulation, by something that gives me a right to come into court. That's called the likelihood of success on the merits. And implicit in all of this, once again, is that money damages are simply not adequate. If money damages could restore someone to their position before the particular order or government action was taken, then you wouldn't need a TRO, right? Because ultimately you can simply give that person whatever the damages, the money damages would be, and make them whole. That's the point. Money will not make them whole if indeed these things are permitted to go ahead, because money simply will not restore a job, will not restore overseas help, will not restore the environment that is compromised by virtue of not going ahead with grants. Millions of dollars of grants to keep our air clean, our waters clean as well. You can't call that back and say simply money will take care of it. That's what injunctive relief is all about. And that's what's going on. And why do I do all that? Why are we doing this examination, this law school course on injunctive relief? Because it's what's going on in all of these instances, which we're now going to talk about as well. In each one of these, and this is also to push back on that notion which my president has talked about, which my attorney general has talked about, that somehow these are judges that are running roughshod over process. They are not. They're following what the injunctive policies and processes and practical implications have been, candidly, for a very long time. Risk of irreparable harm, absent intervention, likelihood of success on the merits, the idea that judges will schedule these things on, take evidence, make determinations ultimately not based upon some knee-jerk reaction, not based upon political animation at all, but based upon what's happening in court. That is the injunctive relief process. That is the function of the federal courts, and they do it all the time in these circumstances, happen to be focused a lot upon what our president, my president, is doing these days, issuing these executive orders, and that's where we're going to get to them right now. Before we do, however, we already have some callers online. We appreciate so much as we get into these particular cases, your comments, your questions, and let's begin with Brian. Brian, we appreciate your call coming into our program this weekend.
Yeah, just a few questions. And
Sure.
Not tying to each other. With everything that Musk is doing with these $100 buyouts, for votes for the Supreme Court, a lot of people are saying that what he's doing is illegal. How can that be stopped? And then the other thing is I've heard from other people that if you take the buyout, that's illegal too. Where do we stand on that?
Right. Lots. Again, this is another issue that, again, who knows? Somebody may go into court and try to stop this from happening here. I think it's important to understand what is and is not proper. Plainly, this is not voting, right? If we know, in fact, that the Voting Rights Act says that if you pay somebody to vote in a certain way, that's in violation of the law. The Voting Rights Act in the 1960s, that prohibited that. That's not this. That's not what's going on. What Elon Musk is doing and his team out there is doing is giving you $100 if you'll sign on to a document that condemns these so-called activist judges, that talks about the judiciary in a way that again, he and others have a right to talk about the judiciary as they want.
That's a part of our First Amendment privilege and our rights. The concern, I think, that an awful lot of people have is that it may not be illegal in the literal sense of the word. It doesn't appear to be a violation of the Voting Rights Act. You're not buying votes. You're asking people to sign up on a piece of paper, an agenda item, a statement that they apparently believe that we've got activist judges who should be stopped somehow. It is concerning. And Brian, I think this is why you're what animates your call, which is that if people really believe that there should be a petition, if there should be this statement that I can sign on to, I should believe that, and I should be able to petition in some way, regardless of how that petition might be used. We don't know where that's going exactly. I should be able to do that without being compelled to, or at least even encouraged to do it by virtue of being paid to do it. $100, and I write my name on this. Am I really committed to the statements in that petition? That's, I think, a lot of the question. It's not so much a buyout as it is a buy-off, if you will, for doing exactly that. And that's the concern there. If indeed at some point, whether it's politically or in the judicial process, the results of this process are brought into the courts, then judges have an obligation to take a look at whether or not these particular statements on these petitions are in fact legitimate. If indeed people were simply paid off to sign their names to it, as you can tell, I have great skepticism about it. We have got a country where, yes, indeed, you can speak about judges, you can be critical of judges. Our Attorney General should be balanced about that, but others can object to the findings, to the decisions that they make without attacking the very integrity of the process. And that's where this system and this particular issue, as it percolates up, becomes more and more problematic. But Brian, appreciate the call tremendously. We'll plainly hear from this again, and it's much related to what we're talking about this morning on our broadcast. We also have Mark calling in. Mark, appreciate your comment or your question this morning as well.
Yeah, I certainly think that the deportation of those Venezuelans to El Salvador is pretty clearly a violation of the Fifth Amendment to the Constitution. I mean, I guess you could stretch and say, well, they posed a public danger, but there's nothing the ordinary legal process could handle those people, to actually arrest them and indict them and, have them, they have a right as persons, they have a right under a Constitution to a trial and not just scooped up, because anybody could get scooped up like this. And, with the president just says, those are my enemies, and scoop them up and
send them off,
with the
right?
Constitution,
Exactly, yeah.
And as far as for this whole immunity for the president thing, is that the president's official duties, I mean, the Supreme Court said in the course of his, applying his official duties, well, one of his official duties is to faithfully execute the law.
Absolutely, absolutely. And this particular law, which we're going to talk about, the Alien Enemies Act, you've got it just right. When we come back, we're going to talk more about, Mark, your very points having to do with process and having to do with the injunction that the judge attempted to impose a week ago. All of that coming up as we talk more about those Venezuelan immigrants. Mark, appreciate the comment, the call here on Amicus, a law review.
You're listening to Civic Media. Find the latest news, information, and archives of all your favorite shows on the Civic Media website, civicmedia.us.
This is Amicus. My name's Jim Santelle. We are initiating with this broadcast, this hour, next hour, a new segment. Perhaps it will last, perhaps it won't. We'll see what history brings, called Injunction Function, talking about the function of federal judges in enjoining actions of the president, and they're doing it across the board. We're going to highlight 5 of them to greater and lesser degrees in this broadcast. Continuing down the road, we necessarily will not be able to address every single one of these, but important to understand what's going on. Important in the wake of Mark's good comment just before the break, talking about the mechanisms by which a president can also be held to account for the things that he, perhaps one day she, does under the law, invoking one of my very favorite aspects of our Constitution, as Mark did, the Take Care Clause. The president's got an obligation to take care that the laws of our nation be faithfully executed. Well, what's this law all about? It's called the Alien Enemies Act. the Alien Enemies Act, and right now it's before a judge named James Boasberg. He is the chief judge of the U.S. District Court in the District of Columbia, and we know what this is all about. We know that a week ago, this weekend, the judge was first addressed by petitioners who were very concerned about decisions made by our government to put on 3 different planes a number of people identified as Venezuelan immigrants, identified by the Justice Department, by the government, as Venezuelan gang members that apparently are part of a group called the Tren de Aragua. And based upon that, they were put on these planes and moved off our nation, brought to El Salvador. And to this day, a week later, now they're in a high-security prison there in El Salvador, plainly outside of our nation now. And what happens is that the petitioners come in front of Judge Boasberg and say, stop those planes from taking off. Stop that from happening because, as Mark just indicated, these particular individuals, regardless of who they are, we don't know immediately who they are, they have not had their right to due process under the law. And indeed, Judge Boasberg issues one of these temporary restraining orders. He says, yes, ground those planes, keep them in place. Do not do this until we can have a full and fair hearing on what's happening here. And we know factually what happened. Again, unclear to this day about exactly what the timing of this is, which is the reason why Judge Boasberg is very, very angry these days about not being able to get a straight answer. But apparently almost contemporaneous with the judge's decision to ground those planes, the planes are in fact in the air. And the question is, did he speak? Did he prohibit those planes from taking off before they did? Or was that order issued after they were already in the air? And was there any attempt even to call them back? And so the judge, in the wake of that initial TRO that he issued that said, keep the planes on the ground or bring them back, has asked the government, the U.S. Department of Justice, your government, to answer some 5 simple questions about when the planes left, who's on the planes, those kinds of things. He is asking for information about what happened here. And he issued that TRO, and for the past week has had a number of hearings, including some just late as Friday, some on Monday, repeatedly postponing an opportunity at the request of the government to be heard on this matter. The Department of Justice saying, we're not yet ready, we don't have the information yet, and the judge exhibiting a huge amount of patience after initially saying, yes, I need this information right now to determine whether or not, number one, the government is in contempt of my order for failing to abide by it. That's the larger rule of law issue. And secondarily, getting to the merits, what about this Alien Enemies Act? Does the government have the right to do this in the first place? Does the president have the right to do this under that old law that basically is applicable when, in fact, we're in a time of war? We'll talk more about that in just a moment or so. Those are the questions in front of Judge Boasberg. So on Thursday, the judge basically said that he is inching toward holding the government in contempt for possibly violating his ruling, pausing the deportation of those Venezuelans under this rarely invoked wartime statute in a very sternly written order. And that's the other lesson from all of these cases. You've got judges who are not responding in a very docile way. They are saying, no, indeed, executive branch, you are violating the law, and don't you dare think about violating my orders. Sternly written order, very, very clear on this. He told the administration to explain to him by next Tuesday. We've got a few more days. He's already given them lots of extensions. They've asked for them. They've submitted other things along the way. He has called the information provided by the government to this point, by your government, as woefully insufficient, his words, not mine, when it comes to answering his questions about what happened here. He's given them until Tuesday to show him in what's called an order to show cause. Tell me why it is you have not violated my instructions when you allowed flights of these immigrants to continue to El Salvador, even after I, the judge, directed those planes to return to the United States. Boasberg called out the efforts by the Justice Department to repeatedly stonewall his attempts
to get this information for the past several days about the timing of the flights over the weekend. He said this: the government again evaded its obligations. Those are words you don't want to hear if you're in the receiving end of those words. He added that the Justice Department, this is Pam Bondi's Justice Department, about the flights again, woefully insufficient. You're not responding to my inquiries here. Went on in later settings to say that the government has been intemperate and disrespectful. He talked about never before seeing this kind of language from a Department of Justice attacking a judge in this way. He issues a 3-page order. It's a remarkable display of frustration by a judge once again, who has given Pam Bondi and the Department of Justice people an awful lot of rope here. He is seeking not only information about this, but also now asking about whether or not this extraordinary invocation of the Alien Enemies Act to pursue the Trump administration's immigration agenda, whether that is legitimate. The government has made these last-minute efforts to cancel the hearing before Judge Boasberg. They run up to the Court of Appeals, telling the Court of Appeals that the judge has no jurisdiction, which is simply wrong. Attempting to stop him from doing that. And of course, all of that leads to further animation. It also, in the midst of this, which we'll talk about later, is the genesis for this spat, this argument between the president, who says, yes, indeed, Boasberg's got to be impeached. Got to be impeached, got to take him out of there because of what he's doing. The supporters of the president have assailed him as a hack, a Marxist, a terrorist sympathizer. Donald Trump himself has entered this fray again, demanding impeachment of Judge Boasberg, prompting the Chief Justice to push back at least on that. He should have done more, but at least on that. When our broadcast continues, we'll talk more about the Venezuelan immigrants, where the case stands right now, and what the injunction function of this court is all about, pending there in the District of Columbia, here on Amicus, a law review.
Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
This is Amicus, a law review. This our second hour of our broadcast here on this weekend, talking all about injunctions and the function of federal courts. As always, taking your comments, your questions, your inquiries at 855-752-4842. Right before the top of the hour break, talking about this story that is at the top of our headlines this weekend, having to do with this spat, more than a spat, between Judge James Boasberg, the Chief Judge of the U.S. District Court in the District of Columbia, and the administration and the Attorney General and the allies of this president. The judge is saying that the responses he has gotten up to this point about whether or not the government, your government, has complied with his order have been woefully insufficient. He's talked about the intemperate and disrespectful nature of their filings, the things they've written, the things that they have said. The entire incident is an ugly one, especially because the judge is asking for some very simple information that can and should be provided readily. He has asked the Department of Justice to provide him with some fundamental basic information, asking for days this past week in various ways to get the administration to tell him, if need be, in camera, under seal. Those are ways of saying you don't have to publish this to the world. You don't have to go into the clerk's office and publish it so that everybody can see it. You can file it under seal, which means only I and the opposing parties will see it. What time did the two planes carrying these Venezuelan immigrants depart the United States of America? What time did they leave American airspace? And what time did they land? More information as well. He's trying to figure out whether or not there was a willful and purposeful violation of the order they entered orally a week ago to bring these planes back, to not have them depart at all. That's a serious problem for the Department of Justice, for the government generally, if indeed he finds out that they purposefully violated his directive. That's rule of law stuff. And that's when the judge does have some remedies here, as do these other judges when it comes to enforcing their orders. You can find parties in contempt, and that's just not a statement. Depending upon the nature of the contempt, there's civil contempt, there's criminal contempt. People can go to jail, and they have gone to jail for failing to follow the orders of judges properly entered in a timely fashion. That is available to him. He has directed Pam Bondi, the Department of Justice, the attorneys appearing in front of him, with whom he is not pleased, to tell him by Tuesday of this week all about this. He is also, and this is equally as Mark has indicated, an important issue. He has also noted that now the government is raising what may be a state secret privilege. That is, we don't have to tell you, we shouldn't have to do any of this because these are all state secrets. On Thursday, the government filed some papers under seal indicating that these answers are forthcoming. But in fact, the judge said the papers filed by the government, by Pam Bondi, repeated the same general information. These are his words about the flights the department lawyers had already given him in previous court filings. Nothing new here about any of this. And he also said that he wants a sworn declaration about the invocation of this privilege, this state secrets privilege, by somebody with authority, with direct involvement in the cabinet-level discussions, he says, about the invocation of this. I don't want some mid-level a person who's going to come in and speculate. He instructed the lawyers from the Justice Department to tell him by Tuesday if the administration intended to actually invoke this state secrets privilege. And again, the government plainly postponing with somewhat the consent of the judge, giving them extended delays, extended extensions in which to respond. All of this, again, against the backdrop of whether the Alien Enemies Act is, in fact, properly invoked here. The statute passed in 1798 gives the government wide latitude, admittedly, during an invasion, that's the language, or a time of declared war. That's the way the statute reads, declared war, probably invoking the Constitution itself. Congress is the one that declares war, right? To round up and summarily remove any subjects of a hostile nation. A hostile nation, that's what the law says, over the age of 14, and describing them as alien enemies. Lots of things to unpack there, of course. The administration says, well, we're under an invasion by these Venezuelan gangs, this violent street gang, Tren de Aragua. And that constitutes an invasion. Unlikely that the judge or any judge would find that that really is an invocation of the Alien Enemies Act, a hostile nation, that these are representatives of that hostile nation, that they're alien enemies. But lawyers for the government are maintaining, presumably, that that's the basis upon which the president is able to do this. Stunningly, once again, our attorney general has said beyond that, this judge has no capacity to even decide what the law is. She has talked about him as being an unelected federal judge. And that's right, he's not. Madam Attorney General, you know that well. Our federal judges are not elected. They're appointed by a president to uphold the law. And you know as well, Attorney General Bondi, that their responsibility to apply the law to the facts and determine whether or not, in this instance, the law, the Alien Enemies Act, has been followed or not. There is certainly, as Mark has indicated, as many people have indicated, as the petitioners themselves have said, these folks were put on these planes allegedly. That's what the judge is trying to get the bottom of as he makes his factual findings. Put on these planes without due process. Who are these people? Are they in fact members of this gang? Are they in fact members of a hostile nation? They are alien enemies, or are they, as many of the court papers filed during the course of this by some of the petitioners, are many of them have nothing to do with this particular gang or affiliation. The premise upon which many of them apparently were rounding up were some tattoos. Some of them have a tattoo of a logo from a favorite soccer team. Another person says that one of the other tattoos was tattooed because he thought it looked cool. Those kinds of things have nothing to do with an Alien Enemies Act invocation of a hostile nation or alien enemies. But the point of all of that is that as these papers are filed, as the parties are presenting these cases, these positions in front of Judge Boasberg, he is attempting to do things by the process. That's the function for an injunction. It may well be too late.
It may well be that there is no calling this back. Probably that is the case. And if there is, in fact, a violation of the law here, of the Alien Enemies Act, then the judge has before him what to do next. Findings of contempt. What kinds of things does he do with respect to the administration having violated the law, arguably? If he makes that finding, not only in violation of the timing of his order, but also under the substantive law itself. That's what he's got in front of him this coming week. Tuesday is going to be a big day once again in front of Judge James Boasberg there in the District of Columbia, all a part of these injunctive attempts to respond. It is a stunningly shocking thing that our Attorney General once again believes that this judge has no ability to engage in this at all. Of course, as I said before, our president also thinks that because of his involvement in this, which is his oath of office, which he's pursuing, he should be impeached, he should be removed. And indeed, he has even said something even scarier. He's talked about how all of these injunctions our president has have to be stopped before it's too late. Before it's too late. What is that about, Mr. President? Sounds an awful lot like not only an exercise or an attempt to exercise some power that he has got still waiting in the wings, arguably a threat against the judiciary. John Roberts again pushes back on that very tepidly, says, well, we shouldn't be talking about impeachment. We'll get to that in just a few moments or so. All of that happening inside this first case that we're talking about here on Amicus, a law review. Let's talk about Elon Musk. Brian called in our first hour to talk about something else Elon Musk is doing these days, having to do with his petition, railing against so-called activist judges and apparently offering people $100 if they'll sign on to that petition. Elon Musk, the subject of another federal judge, this judge, Theodore Chang. He's also a district court judge. He is in the District of Maryland. Efforts by Elon Musk and his team to shutter the United States Agency for International Development. This is USAID. We've spent a lot of time talking about this when this first happened. Those efforts likely violated the Constitution in multiple ways and robbed Congress of its authority to oversee the dissolution of an agency it created. That's not me talking. That's a federal district court judge talking in the context of one of these requests for injunctive relief. That's Theodore Chang, U.S. District Court for Maryland. Appeared to be the first time, at least one of the first times, that a judge has actually been reined in directly. Mr. Musk being told that his so-called team cannot do this based upon the finding, and here we go, that Musk himself has acted as an officer of the United States without being properly appointed to that role by the president. Judge Chang finding you've got no authority, and that's my pushback on this notion that there's a department that somehow he's the secretary or the lead of a department that does not exist. The judge seizing on that concept and saying, whatever you're doing, you haven't been properly appointed. You've got no authority to do that. Judge Chang writing in connection again with this initial order that a group of unnamed aid workers who had sued to stop the destruction of USAID and its programs were likely to succeed in the lawsuit. And what he's doing there is he's invoking that standard, a likelihood of success on the merits. That's exactly what we talked about earlier. He agreed with the contention of those petitioners that Musk's rapid assertion of power here, his claim to be able to do all of this over these executive agencies, including shuttering of USAID, was likely in violation of the Constitution and its appointments clause. The judge went on. He also ordered the agency operations be partially restored. Something that's going to be very difficult given what has happened here, sort of like the planes now being transporting those immigrants to Venezuela. Maybe too late already. Though the reprieve here, again, is likely temporary. He ordered the team reinstate email access to all current USAID employees, including those who are on paid leave. Also ordered that they submit a plan for employees to reoccupy a federal office from which they were evicted last month. He barred Team Musk from engaging in any further work related to the shutdown of USAID. And once again, given that much of the agency's workforce has basically been shut down, the contracts have been terminated, the monies are no longer gone, It's not clear what effect the judge's rulings here would have, but it underscores once again the notion of the immediacy in all of this. Only a skeleton crew of workers are still employed by the agency. But that going on again in Maryland, a district court judge saying, no, you can't do it under the injunctive function of our federal courts. More of that coming up as Amicus, a law review, continues.
This is Amicus, a law review. My name's Jim Santelle, talking about the second of 5 orders we're talking about here on the broadcast. This one issued by Judge Chang just this past week, telling Elon Musk and his group of people, that indeed they should not have anything more to do with the shutdown of USAID. He finds along the way that Elon Musk had personally and unlawfully overseen the dismantling of the agency, offering a firm rejection of the operations authority. In, again, another very sternly worded order. That's the pattern on all of this. You've got judges saying, not only are you violating the law, but let me tell you this in the strongest language possible. Judge Chang warning that any skirting, any violation of his orders would result in holding Musk and members of his team in contempt. What is contempt? Again, it's finding that you failed to follow my orders. And the sanction that judges have is to make that finding, arguably to impose sanctions in the wake of that. That could involve, depending upon the process, even afforded in a contempt proceeding, that could involve jailing. And that may be the remedy that's coming up at some point. Lawyers representing the government, your government, said that, in fact, Musk was not, in fact, the head of this particular agency that's going after USAID. The judge appeared to dismiss those claims entirely, noting again that Elon Musk had targeted and celebrated his actions to dramatically downsize USAID very publicly, including the firing of the vast majority of its workers. Here's what the judge said. He said, DOJ, and yes, he's using that phrase, has taken numerous actions without any apparent advanced approval by agency leadership. No authorization is what he's saying, nothing consistent with the Constitution, with legislation. The judge goes on to reel off a whole list of other examples: the Education Department, the National Institutes of Health, Energy Department, where the Musk team apparently is pursuing these cuts on their own without authority. And Judge Chang says, taken together, these are his words, taken together, these facts support the conclusion that USAID has effectively been eliminated. Stunning again in court, underscoring once again the need for action, immediate action, because we have an administration here that is acting very quickly, postponing the actions of federal judges and keeping not only the challengers at bay, but effectively mooting any actions that a federal judge might be able to take. That's number 2. Venezuelan immigrants, USAID shuttering. Let's talk about the Social Security Administration once again. Elon Musk at the force of a federal judge here as well. Just this past Thursday, a judge, her name is Ellen Hollander. She's in the District of Maryland once again. She issues a temporary restraining order. What does she do? She bars the Social Security Administration from granting Elon Musk and members of his team access to sensitive records stored in the agency's system. Or she says, from holding on to that data they had already taken. Stop doing this. No access to those records. You can't have access to any of the sensitive data. She blocks Social Security's top officials, a fellow named Leland Dudek, who has again loomed large in news recently, and Michael Russo, and the other agency's employees from granting the Musk team engineers entry into their systems. In other words, if the Musk folks show up, Mr. Dudek, Mr. Russo, you cannot give them access to these systems. Her order, appropriately, and this is what judges do, they issue a balanced determination, even at a TRO level, not overstating their own power, their own impact of their orders. She says her order is focusing only on documents like tax records,
that presumably would allow Musk and the others to analyze people at an individual level. And that's the important aspect of this, right? The order, again, from Judge Hollander, Federal District Court Judge Hollander, obliged by her oath of office under the Constitution to enter decisions based upon the law and the facts as she decides them, states that the agency could indeed provide the Musk team with redacted or anonymized, that's a fancy way of saying you render it anonymous, so you redact the information about specific recipients of Social Security benefits that facilitated or somehow supported a broader analysis without running afoul of federal privacy laws. But she says you can't have specific information with specific names and identifying information. We know that these lawsuits, again, focusing upon the Social Security Administration here, are also involved in incursions into the Treasury Department, the Education Department. Judges there have issued similar orders barring these officials from handing over similar sensitive information. And all of this goes on as the courts continue to wrestle with what to do in these emergent and emergency situations. Judge Hollander, she writes a 137-page opinion. It accompanies the order that the intrusion into Social Security data was concerning enough to justify, and she imposes a 2-week restraining order. This TRO lasts for 2 weeks while the lawsuit continues. This is a big deal, she says, and I'm going to impose this TRO for 2 weeks. We're to come back, she says, and in the meantime, that all of my orders have got to be in place. She said that retirees, when submitting their bank information and other financial data to the agency to receive common benefits, had a reasonable expectation that their records would not be used to inform a government-wide effort to slash spending. Here's what the judge says. The unrestricted access of this personal information that the Social Security Administration provided to the Musk team without specified need. Again, this is the kind of thing that judges do. They address what is the nature of the harm here. And she says no specified need here, and or without adequate training. That's plainly addressing the incapacity of this team even to know what it's doing. Detail agreements and or background investigations of these team members, she wrote, using abbreviations for personally identifiable information, and the Social Security Administration, all of that would be highly offensive to an objectively reasonable person. And that, again, that's the standard, right? This is not the judge herself imposing her own personal or even political views. She's saying objectively, this information cannot be, under the law, disclosed to these people. She goes on to say, the expectation of privacy shared by plaintiffs' members, and these are the people who are bringing the challenge, is objectively reasonable. It is almost self-evident, she says, that in our society, this personal information, such as Social Security numbers, medical information, and certain financial records, are regarded as private, sensitive, and confidential information. It is stunning that we have to say this out loud. She's writing this now in her TR orders. It comes, of course, a month after a coalition of labor unions brought these lawsuits to stop Musk and his team. Musk, of course, who's called Social Security a Ponzi scheme, and these efforts to try to stop him from targeting the agency's agenda. Musk has also backed cuts to the agency's call centers, other changes that many people have warned could make customer support a whole lot less accessible, not just in Washington, D.C., but in states around the country. The order imposed by Judge Hollander expires in 14 days. And before then, again, part of the process, the function of federal courts, she's ordering everybody to file motions, give me memorandums, tell me what more we should do to stop this kind of intrusion from happening. Meanwhile, the TRO remains in place, that also coming out of the district court in Maryland. When we come back, 2 more of these, transgender bans and EPA money recoups, here on Amicus, a law review.
This is Amicus, a law review. My name's Jim Santelle. We are spending this broadcast talking about the function of federal courts to entertain requests for injunctive relief, injunction functions of our federal courts. We've already talked about Venezuelan immigrants and USAID shuttering. Social Security Administration. Let's talk about two more of them. Then we're going to get back to callers and texters. So delighted to have so many comments and inquiries about the subject of our broadcast this weekend. Let's talk about another one of these cases. This comes out of the Pentagon. A federal judge just this past week blocked the Trump administration. Yes, another injunctive order, another TRO. This judge is Anna Reyes, R-E-Y-E-S. She's got some very strong language for this administration, stopping the Trump administration from banning transgender people from serving the military. Again, another very forcefully written opinion, rebuking the president's efforts. Anna Reyes is her name. She is a federal district court judge, issuing an injunction that allows trans troops to keep serving in the U.S. military. In other words, you retain your position, do not go away. And she does that under rules that were established by prior administrations until their lawsuit against the Trump administration's ban is decided. And that, again, is part of the process here. Stop this bad thing from happening. We'll figure this all out. We're straightening it all out down the road. But Judge Reyes, again, as do the other judges, says at the very top here, the ban at bottom invokes derogatory language to target a vulnerable group in violation of the Fifth Amendment. The government, the Department of Justice, had argued that the courts have to defer to military judgment. But in her own 79-page opinion, judges are animated about this. They're writing lots because there's a lot to say, and it underscores the ferocity with which they're responding to these plainly unconstitutional and illegal orders from the White House. 79-page opinion. Judge Anna Reyes says the government had thrown together a ban based on next to no evidence, and that, as she said, the law does not demand that the court rubber stamp illogical judgments based on conjecture. A little bit of information here. According to the Defense Department, about 4,200 current service members, or about 0.2% of the entire military force, are transgender. They include pilots and senior officers and nuclear technicians, Green Beret, rank-and-file soldiers, sailors, airmen, Marines, across the board. Despite their relatively small numbers, they obviously provide important contributions to our military forces. They are plainly the focus of President Trump's focus in his executive order. He issues early on this caustically worded executive order that the judge makes reference to. He talks about how trans troops have afflicted the military with radical gender ideology, and that, as he said, the adoption of a gender identity inconsistent with an individual's sex conflicts with a soldier's commitment, listen to this, to an honorable, truthful, and disciplined lifestyle, even in one's personal life. In defending this in front of Judge Reyes, the attorneys, your attorneys from the Department of Justice, has invoked that same language. And interestingly, that the attorneys who are invoking that language and pushing back against the TROs and the injunction here have said that even if there's animus, even if there's anger or hostility toward this group, that is not sufficient. That is not sufficient to overrule the executive branch. Stay away from this. And so, here's Judge Reyes, again, recent hearing. She spends a full day questioning those DOJ attorneys who are defending this policy, showing, as the other judges as well do, great frustration. She goes line by line through reports on transgender service members that the government had cited when the ban was first issued. And she notes along the way that they were years out of date. Antiquated information here. Defense Department's conclusions, she said, were grossly misleading because they cherry-picked one part and misrepresented even that. And if it isn't clear up to now, here's what she says. She says the evidence of this, in support of this directive to get rid of our transgender service members, and in support of the challenge to it, she said the evidence presented by the government was so thin that the Defense Department may well have cited the latest Beyoncé album. That's what a federal judge said in a federal court. She said, how can you even say that a whole group of people lack humility?
She said to the government lawyers, it just makes no sense. Again, pushing back on this theory that well, the president can have animus toward a group, and you've got no capacity to do any of this. The Trump administration's efforts plainly is a remarkable departure, as we know historically, a 77-year trend in military toward welcoming an increasingly diverse variety of Americans. It was generally the White House view that pushing for more inclusion, presidents of all political persuasions, and significantly, military leaders have repeatedly opposed the transgender ban. And nonetheless, there it is, a final footnote. That as a part of this, of course, as we know, inside the Department of Justice, there has been a rollback there, including firing of top military leaders. We talked about those before. Ending recognition of Gay Pride and Black History Months, purging content mentioning diversity and inclusion efforts from the Defense Department websites, and even removing a photo of the B-29 bomber that dropped the first atomic bomb. Why? Presumably because its name, the Enola Gay, was flagged in a search for words the department wanted to scrub. That's what's going on right now. That's what the judge, Ana Reyes, responded to so negatively. She also said along the way she won't be gaslit. She said, I'm not going to let you say some things in public that you don't say here in court. And she also said, again, indicating her frustration, she said, I am not an idiot. Don't take me for a fool, government. I know what's going on here. That's Ana Reyes. She joins, again, Ellen Hollander and Theodore Chang and James Boasberg in pushing back in the strongest language possible. And finally, let's talk about another judge we've talked about a lot. And her name is Tanya Chutkan. Remember her? She is the one who presided while it was pending in that lawsuit, that criminal case against the current president, alleging violations of law in connection with January 6th. Well, the same judge has temporarily blocked just this past week, again, another TRO, another injunctive order, the Environmental Protection Agency, now under the Trump administration, its attempt to recoup, to grab back about $20 billion in Biden-era climate grants. And that's plainly the latest judicial setback for Donald Trump in all of these kinds of things. On Tuesday, U.S. District Judge Tanya Chutkan, yes, she's there in the District of Columbia, she prevented the EPA from reclaiming money that it had deposited at Citibank for the groups Climate United, Coalition for Green Capital, and Power Forward Communities had not only anticipated, but had been granted. The decision did not revive the group's ability to draw from the funds, postponing that decision until after further proceedings. So again, she's entering this tempered order. She's not going down the road completely, but she's also saying, at least initially, you have to stop doing this. She says this, the EPA gives no legal justification for the termination of the contracts. And she goes on to say that the administration has only vaguely outlined its allegations that the grant program was marked somehow inappropriately. Again, this fight over the Greenhouse Gas Reduction Fund, a major front, once again, in the present administration's battle to claw back billions of dollars in former President Joe Biden's climate and clean energy agenda. The three nonprofit groups say they may be forced to lay off employees and cancel long-planned projects if they lose these grants, and that's what Eileen Chutkan is responding to. Rather than declare a winner, the decision plainly was merely aimed at preserving the status quo. That's what Chutkan said. That's what judges do in their balanced approach to all this. Plainly not giving the challengers everything they want. Her order does not immediately restore access to the group's accounts, nor does it officially kill the EPA's right to press for the contract determination, but it does put the brakes on all this. The award's about $7 billion for Climate United, $5 billion for CGC, and $2 billion for Power Forward Communities are designed to do what? They're designed to spur private sector investment in energy-efficient housing, clean energy, electric vehicle charging infrastructure projects, particularly in communities where we know that struggle to attract private sector dollars is important. 5 other nonprofits receive the remainder of the $20 billion total. EPA administrator has repeatedly accused the Biden administration of engaging in inappropriate conduct in connection with the authorization of this. And again, this litigation continues as the judge not only issues this order, but also indicates future litigation on all of this. A lot of that coming up in the days and weeks ahead. That Tanya Chutkan joining Anna Reyes and Ellen Hollander and Theodore Chang and James Boasberg just this past week in entering TROs to stop these things from happening, but do it once again in a functional way that gives credence to the standards by which injunctive orders are entered, and also giving all the parties an opportunity to be heard. And that's what this process is all about. Once again, underscoring the vacuousness and the inappropriateness of our Attorney General saying that these processes are somehow inappropriate, that federal judges are not doing their jobs, referring to them with vicious names, name-calling once again from this administration, all of that wildly inappropriate. When it comes to the Attorney General, who should be above all of this, likewise calling, at least as to James Boasberg there in the District of Columbia, that he himself has no authority. Shame on you, Madam Attorney General. That is not your role. We'll give others the opportunity. You can disagree with the decisions themselves. You can say, you know what, the standards have not been properly met, but these attacks upon the judiciary have got to stop. They're wildly inappropriate. They're inconsistent with our rule of law process in America, and they should be condemned. John Roberts, of course, pushed back on this somewhat. And he said in a fairly tepid order that for more than 2 centuries, it has been established that impeachment is not an appropriate response to disagreement concerning a judicial decision. The normal appellate review process exists for that purpose. And, of course, he's responding to complaints about Boasberg, who is called a radical left lunatic in a social media post. And also, again, from our president, indicating that these nationwide injunctions, presumably calling upon our chief justices, have got to stop before it's too late. What is that about, Mr. President? Well, if you really want to do something, Mr. Chief Justice, write a letter directly to the president and take him on. You don't even mention Donald Trump in your statement. Write a letter that not only pushes back on impeachment, but also says that these attacks, the name-calling, the sense from the Attorney General, from the President, from the White House, that these lawyers who are petitioning on both sides, have a right to be in court and have a right to answer questions by the judges, and the judges, by virtue of their oaths of office, have the obligation under our Constitution and the laws to ask the questions, to make determinations based upon the law and the facts. That's what the Chief Justice should be saying. Give us a more robust, a more full-throated lesson on civics. Call upon you, Mr. Chief Justice, to do just that, and tell Donald Trump, and tell, yes, my Attorney General, that they are wrong when they take just the opposite. Tell the dean of the law school from which our Attorney General graduated. His name is Dean Benjamin Barrows. Tell him that if this is what they're educating their lawyers on at that law school, that they need to do a curriculum revamp, because it's simply wrong. All of that leads, of course, to our wonderful texters and our participants in our discussion. Appreciate very much the comment, for example, from Wendy. She writes, I'm concerned about the recent judgment. I think she's probably making reference to the EPA issue that will essentially put Greenpeace out of business. Can you explain the ruling and what, if anything, Greenpeace can do to get that relief? Well, exactly, that's exactly right, Wendy. When these groups go into court, they are attempting to push back on the executive orders. We'll see what, in that particular case, Tanya Chutkan does about these claims that the rescission of the monies were not appropriate. Jean writes in from Waterloo. She says, as we go further down this road, even heard that they may declare martial law. Obviously a subject for a later discussion, but that the fact that we're even talking about that and invoking what happened, of course, in South Korea not too long ago, the pushback on that appropriate where from the people of South Korea saying, no, we're not going to permit that to happen at all. When we come back, more from our listeners, our callers, about all of this, and then some other commentary about America and the rule of law when Amicus, a law review, continues.
This is Amicus, a law review. This is the final segment of our broadcast this weekend. More of this obviously coming up in the future as well. Appreciate so much our callers and those folks who are texting in as well. Len, talking about this impeachment discussion that's out there between the Chief Justice, the President of the United States of America. Len saying impeachment should proceed when the law is not followed. Absolutely right. There have been articles of impeachment introduced in the House of Representatives against James Boasberg, alleging that he is engaged in high crimes and misdemeanors, which, yes, indeed, that's the language of the Constitution. Again, appreciate very much that comment again from you, Len, saying that impeachment should proceed again when the law is not followed, not when the law is followed, similar to violating one's oath of office. Appreciate that comment as well, Len. We also have on the line, calling in from Merrill, Cornell. Cornell, you've been on the line for a while. Your contribution to our discussion this weekend.
Well, thanks, James. Great show. Yeah, I have two questions or some information. The one is if ISIS comes to a person's door, that they have to have a signed warrant by a judge, or you can't get into you don't have to allow them into the house. Now, I just want to pause here. You're talking about global warming, and that the temperatures in the whole world in January were the hottest in 150 years, and also the CO2 level is the highest in a million years, and that's like wrapping a blanket around the world, and it's going to get a lot hotter. So I'm sorry if I took too much time. I'll let you answer on this.
Not at all, Merrill. Cornell, we appreciate very much your comment here. Again, the comment you make about climate change, those are the kinds of things that, again, in a full-blown hearing in front of Tanya Chutkan, they will plainly look to the reasons why these monies were initially allocated. Obviously, a lot of it's going to be procedural, and the process by which they were doled out the monies to these various groups. But underlying that, anticipate that very likely Tanya Chutkan will talk about some of the underlying reasons for these and whether or not the groups who have gotten these great numbers of dollars indeed are focused upon that end. She's got to have a balanced approach to all of this. So your comment, Cornell, is right on target. And as to the first one, it's actually ICE. It's right. Those are the folks from Homeland Security who are responsible for enforcing our immigration laws here in the United States, along with others. And the general rule is, yes, that's right. Under the Fourth Amendment, this is James Madison stuff. If someone knocks on your door, they need to have some judicial authorization of some kind. Typically a federal judge, could be a state judge as well, could be a magistrate, could be some other judicial officer who says that there's probable cause to believe that there is someone here or some evidence inside this location, could be a home, could be another venue, could be a business, that suggests that there's criminality here. That's our basic fundamental notion. There are exceptions to that. Of course, there's the consent. You can permit agents of the government, state and federal government, to come in. There are exigent circumstances, all kinds of things. But the warrant requirement is fundamental. You've got it just right, Cornell. Those kinds of things. And it goes to the larger issue we've also talked about when it comes to the injunction, the attempted injunction by James Boasberg as to these Venezuelan immigrants and the other cases as well. It's all about process, right? We're not prejudging any of these cases. We're simply ensuring that there are judges who take a look at them and make determinations, for example, in this Fourth Amendment setting about whether there is probable cause. If it is there, then indeed the warrant is issued and authorization is given by the government to go in. If indeed under the laws on all these cases involving USAID, the Social Security laws, and the laws of the Department of Defense, the regulations there, all of these kinds of things, if there's support for doing it, that's the reason why you have these hearings. So people can come in and testify about them, the reasons, the rational basis for our government doing various things, and the connection between those things and the benefits that come to the citizens of the United States of America. All of that highly relevant. Cornell, appreciate your contribution as well to all of this. And we also have a question coming in from Genesee Depot.
as ordinary citizens have standing to file charges over what is being done to Social Security, Medicaid, and Medicare. It's an interesting question once again. The process there, of course, is to petition your elected officials on the policy side of things. That is Medicaid, Medicare, all of those, Social Security. They are creatures plainly of the legislature, right? That's why all these judges are saying, let's take a look what the law said in creating those programs. If indeed the administration is violating the legislation, then we've got to restrain them. We've got to enjoin them from doing that. So a first response is you need to get to your legislature and encourage them to do the oversight and indeed to pass legislation if indeed another branch of government, namely the executive branch, is overreaching on all of that. Can private individuals file lawsuits? Absolutely. In virtually all of these cases we've talked about in this segment of our broadcast, you've got private individuals. You've got individuals who are being tossed out of the military, who are not getting the benefits that they would otherwise get, who are concerned about the exposure of private information, their medical information, their Social Security information. They're concerned, frankly, about family members who are not members of a gang, arguably, and they're now overseas in a foreign prison. They're concerned about not getting the monies to which they were entitled under a process and now compromising the safety, security, the legitimacy of our air and our water. All of those things brought by private individuals. I would offer, especially now, there were times in the past when, yes, indeed, the Department of Justice would do those kinds of things on your behalf. The Civil Rights Division, the Civil Division, all sorts of lawyers inside the Department of Justice, ensuring that private individuals, even entities of government, are following the law. In this administration, and this is the concern underscored by all of these injunction function illustrations, now we have got just the reverse. And so private individuals, Jim, again, your comment from Genesee Depot, you're the ones who need to file these lawsuits. And this is the reason why, once again, the attorneys are so very important here, not only in putting together the bases for these, but making the cases. The importance of lawyers in advancing the rule of law, the importance of federal judges as one of our guardrails, other systems also out there. We talk about more of this, including next week, more about what's happening when it comes to law firms and institutions of higher learning in America. Program note for next week, we'll talk more about that as Amicus Law Review continues here on the broadcast stations of Civic Media every weekend. Join us for those future discussions. Thanks for being with me this weekend. Have a good weekend, everybody.
The national news cycle never stops, but it can be hard to find news about your local community. Civic Media is dedicated to providing quality local and state news coverage across Wisconsin. With the Civic Media app, you can get notifications about local stories that matter to you and your community. Find the free Civic Media app in your phone's app store and choose notifications from the menu to tell us what kind of news you want to hear about.